Hi, everybody. Welcome to the webinar. I'm going to be waiting some time for everyone to join in the webinar. Something for you guys to keep your eyes on or keep tabs of is I'm trying to use my head to block the window behind me because I know that best practices are that there's no window behind you. But this is the best place I found in my house to do the webinar, but I just don't have anything back there to block the window. And for whatever reason, when I bought this house, it had no blinds or shades or anything. And 2 years later, I'm still sleeping on a mattress on the floor. So naturally, I haven't gotten blinds for my windows yet. But it's on my list of things to do. So I think like my neck, it's covering most of it, but really kind of hoping I get that announcement soon that you're all in the room and I can just get started. Oh, thank goodness. So hi, everybody, and welcome to the Election Cases webinar. I am Lisa Soronen with the State and Local Legal Center. This webinar is a joint event with the SLLC and 3 National Conference of State Legislatures programs and committees. Research, editorial, legal, and staff and committee staff, relax. Law, Criminal Justice, and Public Safety Committee, and Elections and Redistricting Program. A few housekeeping matters before we begin. Kay Warnock, who most of you know, is going to put in the chat some handouts for today's webinar. The webinar is being recorded. It will be available on the State and Local Legal Center's website and NCSL's website as well. If you have questions, you can put them in the question box. It's also okay if you put them in the chat box, but there is a specific question box. If you have technical difficulties, please send a message via the chat box and you will get a response. The views expressed in this webinar do not necessarily reflect the views of NCSL, the SLLC, or SLLC member groups. So as I said, the SLLC has co-organized this event. For those of you who are new to the State and Local Legal Center, the SLLC files amicus briefs to the Supreme Court in cases affecting state and local government on behalf of the Big 7 national organizations representing state and local government officials, including, of course, NCSL. NCSL was founded in 1975. It represents legislatures in the states, territories, and commonwealths in the United States. Its mission is to advance the effectiveness, independence, and integrity of legislatures and to foster interstate cooperation and facilitate the exchange of information among legislatures. Now, I'm pleased to introduce our speakers. Jessica Ring Amundsen is a partner with a law firm of Jenner and Black. Aaron Murphy is a partner with a law firm of Kirkland and Ellis. Susan Parnas Frederick is Senior Affairs Counsel with NCSL. So, Ronavik versus DNC is the biggest election case since Shelby County. Jessica, please tell us more about this case and what it means for state legislatures.
Thanks so much, Lisa. I'm delighted to be here and always appreciate the wonderful programs that NCSL and the SLLC put on. And thanks to all of you for joining us today. As Lisa mentioned, I'm a partner at Jenner and Block, and I chair our election law and redistricting practice and co-chair our appellate and Supreme Court practice. And I argued the Brnovich case that we're going to be discussing today on behalf of my client, the Arizona Secretary of State, Katie Hobbs. Before we dive into the case, just a little bit of background to set the stage. So, of course, the Voting Rights Act is kind of the landmark piece of civil rights legislation. And as originally enacted, Section 2 of the Voting Rights Act prohibited states from imposing or applying election practices or procedures that would deny or abridge the right to vote on the basis of race or color. And in a 1980 case called City of Mobile versus Bolden, the Supreme Court held that the protections of Section 2 of the Voting Rights Act were just coextensive with the protections afforded by the 15th Amendment, such that plaintiffs would have to show that there was intentional discrimination against them in order to make out a claim under Section 2. So in 1982, shortly thereafter, Congress reacted to that decision by amending Section 2 of the Voting Rights Act. And the amendment provided that states could not impose a voting practice or a procedure in a manner which would result in the denial of denial or abridgment of the right to vote on account of race or color. So essentially, what Congress does in 1982 is affirms that what it means is that Section 2 has a results test, not an intent test. There's also a separate provision of the Voting Rights Act, Section 5, which required that jurisdictions that were covered had to submit any change that they wanted to make in their voting processes or procedures to the Department of Justice or to the district court in DC in order to be pre-cleared before the provision could go into effect. And the jurisdiction had the burden of proving to DOJ or to the district court in DC that the new practice would not result in the denial or abridgment of the right to vote on account of race or color. And so in effect, Section 5 really stopped many jurisdictions from imposing any sort of voting practice or procedure that could result in, that could create a disparate impact for minority voters. Of course, in 2013, the Supreme Court decided the Shelby County versus Holder case, and that case invalidated the coverage formula under Section 4 of the Voting Rights Act, which essentially rendered Section 5 a nullity. So jurisdictions no longer have to get pre-clearance of voting practices or procedures. Literally the day that Shelby County was decided and the day after Shelby County was decided, some states then enacted new voting laws, such as photo ID requirements, cutbacks in early voting, and new restrictions on absentee voting procedures. And a bunch of those sorts of procedures were then challenged under Section 2 of the Voting Rights Act, because Section 5, of course, was no longer in effect to stop them from going into effect. They went into effect, and then plaintiffs had to then challenge them under Section 2. So a bunch of these cases sort of make their way through the lower courts, and the lower courts establish a test that is largely drawn from the Supreme Court's jurisprudence under vote dilution cases, which says that what they're going to look at first is whether there is in fact a disparate impact on minority voters as compared to white voters. And then secondly, whether it is the challenge practice interacting with social and historical conditions that is causing that impact. And so the cases kind of reach different outcomes in different circuits based on the particular facts of the case, which is not necessarily surprising, because what Section 2 also calls for is an intensely local appraisal of the circumstances on the ground, and likewise calls for consideration of the totality of the circumstances. So that's actually in the statutory language, to consider the totality of the circumstances. So that brings us to the Brnovich case, which is at issue. So in 2016, prior to the 2016 election, the Democratic National Committee challenged 2 Arizona voting practices and procedures. So the first is something called the out of precinct policy. And that policy required that in Arizona, if a voter cast a ballot in a precinct in which that voter did not reside, that the ballot would be thrown away rather than counted. And that was true even if the only thing on the ballot was statewide races or presidential race. So things that the voter was indisputably qualified to vote for, nonetheless, the ballot would get thrown away. The second thing that the DNC challenged was something called HB 2023, which criminalized the collection of someone's voted ballot by anyone other than a family member, a caregiver, a household member, a postal worker, or an election official. And so while Arizona had long criminalized fraudulent collection of ballots or attempts to influence people in casting a ballot, what the new law did was criminalize non-fraudulent collection of ballots. So even helping an elderly neighbor take a ballot to the mailbox now would result in up to 2 years in jail and $150,000 fine. So the facts at trial showed, with respect to both of these policies, first with respect to the out of precinct policy, the facts showed that Arizona was a real outlier when it came to application of this policy. Arizona discarded provisional ballots cast out of precinct at a rate 11 times higher than the next closest state. And of the ballots that were discarded, the rate was that minority voters' ballots were discarded as compared to white voters' ballots at a rate of 2 to 1. The facts also showed that precincts tended to change much more in minority neighborhoods than in non-minority neighborhoods. Secondly, with respect to the ballot collection statute, the facts at trial showed that the impact was really greatest on Arizona's Native American communities, which lived on reservations, which often did not have home mail service. And the facts showed that a large part of the population needed to travel upwards of 40 to 50 miles to get to a postal service or other state or county facility. Also a great impact on rural Latino voters who rely, and both of these populations, Native American voters and rural Latino voters, relied on ballot collection in a way that white voters in Arizona did not. And so criminalizing this practice obviously would impact them. The district court did uphold the challenge practices, and a panel of the Ninth Circuit similarly upheld the challenge practices. But then the Ninth Circuit went en banc and reversed and held that these two Arizona practices, in fact, violated Section 2, applying the results test, the same test that had been used by lots of other lower courts. The Arizona Attorney General and the Arizona Republican Party, which had intervened in the case, then took the case to the Supreme Court, and the Supreme Court granted cert and heard the case this past year. So in the briefing, what folks were really focused on was the test that was going to apply, because this is the first time that the court had actually heard a challenge. They're called sort of a vote denial challenge under Section 2, as opposed to a vote dilution challenge under Section 2. And the parties proposed various tests. So the Arizona Republican interveners proposed that, in fact, Section 2 should not apply at all, so long as practice was facially neutral. So a neutral time, place, and manner restriction of elections, Section 2 just would have no applicability to it all, regardless of how it impacted the voter. The Arizona Attorney General took a more modest position that focused more on the number of people who were affected, and also urged the court to take into account the alternative methods that the state provided for people to vote. So if people were not able to vote one way, the court should take into consideration alternative means of voting. The Democratic National Committee urged the court to simply adopt the test that had been in use, the two-part test that had been in use by all of the lower courts. The Justice Department also filed an amicus brief in the case, and the brief was actually filed prior to the change in administration in January 2021. And the brief essentially urged the court to adopt a three-part test that relied heavily on causation and also on state's justification. The Department of Justice then, after the change in administration, sent a letter to the court saying that they actually no longer were standing by the test that they proposed. So there were also just dozens of amicus briefs filed, some of which proposed their own tests. And many of which were really focused on urging the court to focus on the importance of Section 2 and trying to steer the court away from any suggestion that Section 2 was unconstitutional, as the Arizona Republican Party had suggested in its brief. So in the interest of time, I'll skip over describing the argument, but it was a somewhat different experience than the last time I argued in the court, because I did it from a speakerphone in my basement, as opposed to from the sort of majestic courtroom at the court. So also a little bit different because the court, while they were doing these telephonic arguments, simply asks arguments in order, or asks questions in order of seniority, as opposed to the much more kind of free-flowing exchange that you have in in-person arguments. But it does mean that you hear from all of the justices. So questions from Justice Thomas, who prior was ordinarily pretty quiet at oral arguments. So it was an interesting experience, and then the waiting began until we got the opinion on the very last day of the term. So it was a 6-3 opinion authored by Justice Alito, with Justice Kagan dissenting on behalf of herself, Justice Sotomayor, and Justice Breyer. So Justice Alito's opinion began with sort of a disclaimer that this was the first time that the court was sort of entering into this space of this new vote denial claims, and sort of disclaimed that the court was announcing any test that would govern all of the cases that would follow that challenge neutral sort of time, place, and manner restrictions. Then Justice Alito's opinion proceeded to say, I'm nonetheless going to set out these 5 guideposts that govern our decision today, but they're not exhaustive, but here's sort of what's guiding our analysis. So the first thing that Justice Alito says really matters is the size of the burden that is imposed on the voter. So he says, you know, kind of the ordinary burdens of voting aren't enough to show that your right to vote has been impaired, and mere inconvenience is not enough. So courts have to take account of kind of how severe the burden really is on the voter. The second thing he says, relatedly, is that courts should take account of how far the practice departs from what was in existence in 1982, when the court amended Section 2 of the Voting Rights Act. And he points out that in 1982, most states required voters to vote in person and had only very limited sort of categories of people who could vote absentee or early. And so he suggests that 1982 is kind of a relevant benchmark for measuring what the ordinary burdens of voting should be. So we should all go back to the early days of the Reagan administration, when we were wearing, you know, leg warmers and shoulder pads and all of those fun things. I'll just say as an aside that while the other 4 guideposts that were part of the court's opinion were all sort of aired out in the briefing, this return to 1982 was something that Justice Alito himself made up and brought up at oral argument. No party had briefed it. It had not been discussed at all, but is now, so no party, including us, had an opportunity to respond to that. However, it's now, of course, enshrined in the court's opinion. So the third guidepost after the return to 1982 is the size of the disparity as between minority voters and non-minority voters. And Justice Alito kind of warns against using sort of statistical tricks to make a disparity appear larger than it otherwise is. The fourth thing that he says is that you have to consider the state's entire system of voting. You can't simply consider the challenge practice in isolation. So if a state shuts down one form of voting for voters, you have to consider that in light of the other opportunities that the state nonetheless affords people to vote. And then finally, Justice Alito says that courts should take account of the strength of the state's interests in why it's adopting the challenge practice. And he goes out of his way to say that one strong and entirely legitimate state interest is the prevention of fraud. And then secondly, that ensuring that every vote is cast freely without intimidation or undue influence is also a valid and important state interest. So the court then went on to apply those 5 guideposts to the facts of the Arizona case and the facts of the challenge provisions, and to find that they did not violate Section 2 using these guideposts. Justice Kagan, as I mentioned, wrote a very strongly worded dissent in which she said that it was, quote, tragic that the court has yet again rewritten in order to weaken a statute that stands as a monument to America's greatness and protects against its basest impulses. Justice Kagan spends a lot of pages kind of chiding the court for purporting to take a textualist analysis of Section 2, when in fact the text of Section 2 is actually quite broad. And then she goes on herself to apply what she thinks is the correct reading of Section 2 to the actual facts on the ground, and shows how the majority really kind of failed to grapple with the real impact of the challenge practices on minority voters in Arizona, and in particular, Native American and Latino voters. What does this all mean for state legislatures, which is sort of the question you asked me at the outset, Lisa? So, I think what it means in terms of adopting new election laws or procedures, it will certainly make it, most narrowly, it will make it more difficult for plaintiffs to challenge the procedures that were at issue here. So things like out of precinct policies or ballot collection statutes. More broadly, I think that it could make it harder to challenge any law that sort of where a state has expanded voting opportunities beyond what it provided in 1982, which is mostly all states. If the state then cuts back on the additional opportunities it has provided, using 1982 as a benchmark could make things more difficult for plaintiffs to challenge such a law. However, there are things that just weren't around in 1982 and so it's unclear how that kind of 1982 benchmark is going to apply to something like voter ID laws, which weren't sort of a part of the conversation at all in 1982. And then, I think overall, while the court kind of went out of its way to say that it was not announcing a test, I think it will be, hard for lower courts to ignore these 5 guideposts that the court set out. Although, the court did say a couple of times that these were not exhaustive and that the statute does demand kind of a consideration of the totality of the circumstances. So certainly this is now being actively litigated in a lot of cases, sort of what Brnovich means and how it applies to some procedures that have been enacted in recent years. And I'll say as someone who represented one of the parties in the case, the silver lining is the court certainly was invited by the other side to opine on the constitutional foundations of Section 2, and the court declined to take that opportunity at all. So it doesn't appear that, although there was a lot of amicus briefing in particular about this, that the court sort of wanted to go at all in the direction of suggesting that Section 2 was unconstitutional. And, so I think the major takeaway is that Section 2 remains, albeit in a more limited form, and unless and until Congress does what it did back in 1982 and overrules the court's interpretation. And I think Susan will be talking more about that later today when we see sort of the federal legislation that's on the table.
Thank you, Jessica, for that in-depth explanation of a rather complicated case. Aaron, before you talk about Americans for Prosperity versus Bonta, if you have any additional thoughts you'd like to add on the meaning or impact of Brnovich, please go ahead.
Yeah, sure, absolutely. I always thought about this case as this is a gross oversimplification, but kind of a high level way that I think is helpful for those of you out there who pass laws and are thinking about how the court's going to think about them. To me, it was sort of a question of when you look at a law, if you have a law that has, that the way it impacts people does disparately impact minorities, but the law impacts kind of very, very few people. What do you care about? Do you care about the fact that the law has the disparate impact, or do you care about the fact that it doesn't impact lots and lots of people? And here, to put that concretely, I think there was pretty strong evidence that the law, the people who use these practices skew minority, but there was also very strong evidence that very, very, very few people, less than 1% of voters, use these practices. And I think that's sort of what the court was kind of thinking about. How do we, do we look at a law in isolation? Do we look at it in conjunction with all of the things out there, the ways people can vote, and how do we kind of balance all of that out? Here, I think that from the majority's perspective, this was kind of on an end of the spectrum that made it easier for them to think about it as, well, if we're looking at totality of the circumstances, that the fact that we've got very few people using these particular practices kind of matters. And the fact that at least one of these practices is something that more than half the states have, and states have had in place for about 50 years, matters a lot too. On the other hand, you got a practice here too with the so-called ballot harvesting that was a little bit newer and, didn't quite have that same history. And there, I think the court, again, though, focused a lot on that notion of, okay, what is the broader impact, not just the impact of the law, the particular law we're looking at. So I think, in looking at these cases going forward, I do think it's a little bit of a caution from this court that, they don't love the idea of kind of plucking laws and in isolation out of the entire voting scheme and saying, let's look at how this one impacts certain voters. And they want to look at all the laws together. And I think one of the important things is, it's quite striking, to Jesse's point, that the opinion says nothing about constitutional avoidance or really about the Equal Protection Clause. But it was such an elephant in the room here. And, so many of the justices, several that are on the court now, have expressed concerns or at least acknowledged that there is tension there. And if you go, Jesse knows better than anybody, some of the questions that were coming at argument were questions on both sides that were kind of, if we do this isolation practice and look at laws and pluck them out, aren't you going to be able to show that practically every law creates greater burdens for minority groups, disadvantaged groups, people who everything that's a burden is more of a burden for? And I think the court has real concern about that, and that this court is really thinking about, we do want to strike that balance of not having the judiciary completely micromanage state election laws. So, to me, it's very interesting that on the one hand, you look at this and it's obviously an area where this court is pretty sharply divided. On the other hand, you did not have a conservative majority go with anywhere near kind of the broadest rulings they could have had, either in interpreting the statute or in kind of bringing up constitutional avoidance, tells me there's still a lot of room among the new conservative majority on the court where they're thinking about where they want to go with all of this. But it is one of those areas where this court does seem, pretty sharply divided already.
Thank you, Erin. Thank you, Erin. And with that, on to Americans for Prosperity.
Sure. So, we might as well stick with cases that sharply divided the court, which, to be fair, was not really, there's actually relatively few cases this term that were 6-3 along sort of what we would think of as the traditional ideological lines, but you're hearing about 2 of them today. So don't let it skew your perspectives of everything that the court was doing this term. But so Americans for Prosperity is a case that really important case, both for purposes of kind of election law and campaign finance type regulation and donor regulation in particular, but also I think more generally for the way the court thinks about levels of scrutiny that could have much broader implications beyond this case. So this case involves a California regulation that requires charitable organizations to disclose to the state attorney general's office the identities of anyone who donated more than $5,000 in a single tax year. The basic thinking behind it, this is not disclosure. It was not supposed to be disclosure of this information publicly. It's disclosure to the attorney general for purposes of doing like auditing and investigating and internal reasons, just to make sure charitable organizations are doing what they're supposed to be doing. It's been on the books for a while, and the attorney general basically didn't really enforce it for many years. And so a lot of charities just kind of didn't comply and out of not wanting to basically out of wanting to protect the identities and the privacy of their donors. And for a long time, the state kind of did nothing about it. But around 2010, the attorney general began ramping up efforts to enforce the provision and started sending a bunch of charities deficiency letters saying, if you don't start complying with this, we're going to take away your licensing, et cetera, to remain a charitable organization in California. So among those organizations that received those letters were the 2 organizations that ultimately are in this lawsuit, Americans for Prosperity and the Thomas More Law Center, which are basically 2 conservative-leaning tax-exempt charitable organizations. After they started getting these letters, they ultimately both decided to bring facial First Amendment challenges to the regulations, arguing that it violated both their First Amendment rights and the First Amendment rights of their donors. And the basic argument was that that disclosing the identity of their donors could subject them to harassment and reprisals, which would violate the donor's First Amendment rights, and the threat of those kinds of actions could deter donors from donating at all, which violates the First Amendment rights of the organizations themselves. This is another case that by the time it came to the Supreme Court had gone through a full trial with a district court, actually making a lot of factual findings that I think ended up being pretty important in the way the Supreme Court resolved the case. And this case too was a case where the district court had ruled with the charities and ultimately got overruled by the Ninth Circuit. But sticking with the district court for the moment, so the district court made findings. First, found there was evidence that the charities themselves had received threats and harassing calls and emails over the years based on the views that they espoused. And based on that, the court found that there really was a genuine risk, both that donors could be subjected to the same kind of treatment and that the mere fear of being subjected to that kind of treatment would chill First Amendment activities. So found that, that this requirement did impose real First Amendment burdens on both the organizations and their donors. On the flip side, the court found, based on testimony from the state's own witnesses, that the state basically never was using this information to investigate or audit charities. They basically acknowledged that it kind of wasn't serving a whole lot of purpose. And then the third set of factual findings that I think probably were pretty damaging for the state in this case was basically the state was proven to have kind of been just woefully inept in keeping the information confidential. They had inadvertently posted thousands of the disclosure forms on their website, and it was kind of like comically easy to access all the rest of them. If you just figured out how to, change a number in the URL site, you could basically get anything you wanted. So the district court and made these findings that we had real burdens here. It wasn't really advancing a state interest, and there was real concern about kind of tailoring, even to the extent there was an interest being advanced. And based on all of that, the court found that it didn't satisfy tailoring for First Amendment purposes. This case, again, also came out of the Ninth Circuit. It went up to the Ninth Circuit, which reversed. And kind of one of the important things I think that ended up being important in the Supreme Court's analysis and was important in the Ninth Circuit's analysis was how the court thought about what level of scrutiny should be applied here for when determining whether the state had met its interest of its burden of showing that it could impose this kind of regulation. So traditionally, disclosure laws, and there's kind of a very small universe of laws in the campaign finance type area. Disclosure laws, and the other one principally being contribution limits, have been subject to what is deemed exacting scrutiny. What exactly exacting scrutiny, is that intermediate scrutiny? Is it something more? What exactly that entails? I mean, you could read decades of Supreme Court cases and find different descriptions over time, all the time, shocking, not shockingly, changing a little bit with the composition of the court as the cases are coming out. But, it's been an area of a lot of confusion. And the Ninth Circuit took, I think it's fair to say, a pretty kind of lax view of what exacting scrutiny was here, kind of saying, as long as a law essentially advances the state's interest in some way and the state has an important interest, that's all kind of good enough for government work. So Ninth Circuit reversed the district court, and the case came up to the Supreme Court, where, as with Brnovich, we ended up with a decision on the last day of the term, again breaking down on 6-3, kind of traditional conservative liberal ideological lines. So the Chief Justice authored the majority opinion, which was joined for the most part by all of the justices. I'll mention a few areas where they disagreed a little bit. The opinion relied in large part on the court's seminal decision from back in the 1950s in the NAACP versus Alabama case, which had held unconstitutional an effort to force the NAACP to disclose its members, which at the time was something that had been clearly done for purposes of trying to find their identities and basically harass the members. And relying in large part on the principles established there and the findings that the district court had made here, the court held that this regulation was unconstitutional, finding, to quote how the chief put it, that there was a dramatic mismatch between the interest that the Attorney General seeks to promote and the disclosure regime that he has implemented in service of that end, and noting that the Attorney General could not identify a single concrete instance in which preemptively collecting this kind of information from charities had done anything to advance the Attorney General's investigative, regulatory, or enforcement efforts. The analysis really, I think, was largely driven by this question of kind of what level of scrutiny should apply and what that level of scrutiny should look like. There was a little bit of debate about what the level is, but all 6 justices did ultimately agree on one thing, which is exacting scrutiny actually means exacting scrutiny, which ends up being pretty darn close here to strict scrutiny. The Ninth Circuit had interpreted exacting scrutiny to ask only whether a law, quote, bears a substantial relationship to an important government interest. The Supreme Court said that is a necessary qualification, a necessary aspect of the analysis, but not a sufficient one. What you have to have under exacting scrutiny is narrow tailoring. The law has to be narrowly tailored to serve the government's purposes. That's a pretty important holding because, I mean, what the Ninth Circuit had said, and plenty of courts have said in the past, was no, narrow tailoring is reserved only for strict scrutiny cases. You do not need narrow tailoring for exacting or any lesser form of scrutiny. The Supreme Court very clearly rejected that and held that even if strict scrutiny is not applying here, exacting scrutiny requires that narrow tailoring. The court made clear that a court engaging in exacting scrutiny has to look not only at is there an interest, is it being furthered? It also has to look at, did the government have at its disposal other less burdensome means that it could have employed to advance its interest, which all ends up sounding awfully close to strict scrutiny. And ultimately the court basically said, to answer the question of what's the difference between the two, I took the court's answer to be the only real difference is for strict scrutiny, you have to have the absolute narrow, most narrowly tailored means of advancing the interest, whereas for purposes of exacting scrutiny, they just have to be narrowly tailored. So I guess there's some delta between, the first narrow, the second, and the third. But that's essentially where the court ended up on the level of scrutiny. And I really do think that, drove in significant part where the court ended up here. Where there was a little bit of disagreement among the justices in the majority is whether exacting scrutiny was even the right standard to apply or whether strict scrutiny should apply. There had been a lot of briefing, kind of much like there was a lot of briefing on the constitutional issues in the backdrop of Brnovich. There was a lot of briefing here, and for a long time, there's been, a lot of an effort to kind of do away with this idea of exacting scrutiny and say, look, donation, confidentiality issues, contribution limits, all of these things that have been in this exacting bucket really should be strict scrutiny. It's all burdens on First Amendment activity. The plurality of the court, the Chief Justice, Justices Kavanaugh and Barrett, said, no, we actually are holding that exacting scrutiny is the right scrutiny to apply here. Justice Thomas wrote separately to say he would have applied strict scrutiny. And Justices Alito and Gorsuch wrote separately and said they just didn't see any need to decide which level should apply because they agreed that this law failed even under exacting scrutiny once exacting scrutiny is correctly understood to require narrow tailoring. Justice Sotomayor authored the dissent here, which was joined by Justices Breyer and Kagan. A lot of her dissent was a very detailed discussion of the factual record and whether there really was a sufficient record here to find that there was a genuine threat that disclosing this information to the state would actually expose anyone to threats, harassment, or reprisals. She also had a lot of discussion in her dissent about that the breadth of this opinion could put a lot of disclosure laws into at risk of being invalidated under the First Amendment. I think that's really kind of one of the key interesting questions coming out of this case is just how broad is this opinion and how much impact will it have? And, I don't know, obviously time will tell, but I would hesitate to read this as a decision that is saying, you can never have any kind of disclosure laws and they're all on the chopping block. I mean, for one thing, if that was really where the court was going, you'd think they might have, all gone in favor of strict scrutiny. But for another thing, I mean, I really do think here, and I think this is true of both of the cases we talked about today, that, I mean, it helped the majority and mattered to the majority that you had a district court that had held a trial and made factual findings that supported concluding that this particular law imposed real burdens. And, I think it was really unhelpful to the state that they had kind of nothing to show that they really needed this information and looked pretty darn careless about safeguarding the privacy interests of the donors in collecting the information. So I think all of that, could very much distinguish this from a case where you came in with a more traditional disclosure requirement, the kind of things that have been around forever, where a state is able to very clearly show, here's, this serves a purpose. It's been serving a purpose for a long time. The court made a point of kind of noting that its decision didn't necessarily invalidate things like the requirement to tell the IRS, who donors are for purposes of them being able to see, if the people who are taking tax deductions really made donations. So, I think there's aspects of the decision where the court was kind of making clear that it wasn't necessarily trying to suggest that it's all the way ready to say that there's such strong interests in privacy and anonymity and all that you can't have any kinds of disclosure regimes at all. But that said, I do think this puts the onus on those of you in our audience who work for states and have those kind of laws that, next time around, you better have a real record to demonstrate we actually need this. And here's the work it's doing. And here's what we're doing to make sure that we are safeguarding the information that, this privacy interests of the individuals at stake here. The last thing I'll say is, I actually think that one of the equally important things to watch coming out of this opinion is just how broad is this holding about the meaning of exacting scrutiny and the need for narrow tailoring. I personally am of the view that this seems to have been a little bit of a pet project of the Chief Justice and a few others for perhaps the past decade. There's been a series of cases, and starting with a case I argued about a decade ago, Mccutchen versus FEC, where the Chief Justice wrote a plurality opinion saying, we don't need to decide whether strict or intermediate scrutiny applies to contribution limits because intermediate scrutiny has real teeth, and it's this strong standard that requires narrow tailoring. That was a plurality opinion, and this opinion gave him a chance to block quote his discussion from Mccutchen and now say this is the holding of the court. There's been a series of cases in which the court was applying intermediate scrutiny, but nonetheless said intermediate scrutiny requires narrow tailoring. That obviously matters a ton for things like disclosure regimes and campaign contribution limits and other areas that have so-called exacting scrutiny. But I can tell you this is hardly the only area where this issue gets litigated. I mean, I've been litigating the question of what intermediate scrutiny means in the Second Amendment context for the better part of a decade now, and the court may say something about that pretty soon. So I think that's really something to keep an eye on, the impact of that, and the extent to which this reflects a little bit of the desire. If you go all the way back to actually the argument in the Heller case, where the Chief Justice referred to the whole regime of tiers of scrutiny as baggage that we don't necessarily need to keep importing into different areas of constitutional law. So I think that's just sort of a bigger picture aspect of this case that's really interesting and something to keep an eye on down the line.
Thanks, Erin. Before we turn the conversation over to Susan to talk about what's going on the Hill, Jessica, do you have any thoughts on Americans for Prosperity?
Sure. Thanks, Lisa. And thanks, Erin. That was terrific. I'll say one thing that I have always struggled with, and that really struck me about sort of this case, these two cases coming down as a pair on the last day of the term, is just the complete dissonance and disconnect between the court's campaign finance jurisprudence and its voting rights jurisprudence. So as Erin knows well from arguing Mccutchen and other cases that she's litigated, in the context of campaign finance law, as Erin was describing, the court requires a state who is trying to limit a person's ability to spend money in elections to have a real justification for any law that it wants to pass, to have evidence that there are problems that it is trying to solve, and to show that the law that is trying to pass is actually narrowly tailored to address that problem. So when it comes to protecting someone's right to spend money in elections, the court demands a real record and narrow tailoring showing that the state really actually needs to do this. Then you come to the court's voting rights jurisprudence. And instead, what the court does is essentially say, a legislature that waves its hands and invokes the specter of fraud, that's essentially enough to pass any kind of restriction on voting. So, for example, with respect to the ballot collection law that was at issue in Arizona, the record showed that Arizona had for 25 years allowed people to collect ballots and deliver them to election officials, that there had literally never been a single instance of anyone trying to fraudulently collect a ballot, that there had not been any prosecutions ever for this under this law. And yet the state sort of said, there's a possibility of fraud, and we're going to pass this law that criminalizes helping your neighbor deliver their ballot to the post office. And the court demanded nothing in terms of a showing that this was an actual problem and or that the law was actually narrowly tailored to address the problem of fraud. So it's one thing that I've just always struggled with is the level of protection that the court gives to a person's right to spend money in elections as compared to the level of protection that the court gives to a person's right to actually vote in elections. And that's something that you know, I continue to just find very problematic in the court's jurisprudence.
Thank you, Jessica. So Susan, tell us what's going on the Hill regarding proposed federal voting rights legislation, and if we're likely to get something passed in the near future.
Well, I'm not going to pull out my crystal ball just yet, but I will say that against the backdrop of both of these Supreme Court cases, there has been a congressional push that actually began before either of these two cases were heard by the Supreme Court. H.R. 1, the For the People Act, and H.R. 4, which is the John Lewis Voting Rights Act. And I'm going to talk briefly about H.R. 1, even though it is an 800-page piece of legislation, because when I do pull out my crystal ball, I feel as though this bill is dead. And I will also say, as a general thought, if any of these two bills, either of these two bills pass, they will most definitely be challenged in the courts and will make their way up to the Supreme Court at some point. So briefly about H.R. 1, it is a comprehensive voting bill. It addresses the voting process, it addresses redistricting, it addresses campaign finance, and it seeks to very much reform all of those areas. And this bill is not a new bill. It did pass in the last Congress before election 2020, and it has again passed in the House, only in the House, in this current Congress, so after election 2020. The biggest issues that NCSL took part in with this particular piece of legislation was the redistricting reforms that it contained. And politically, for this bill, under the normal Senate process, there needs to be 60 votes for cloture, which is the process that the Senate uses to end debate on the bill. And the Democrats do not have those 60 votes, and we can look to Senator Joe Manchin of West Virginia, who is not supporting H.R. 1. In the alternative, Majority Leader Chuck Schumer from New York can do away with the filibuster for voting rights bills only, and that has some precedent in past Senate acts, because as you all may recall, when there were confirmation hearings for our newest Supreme Court justices, then Majority Leader Mitch McConnell from Kentucky did away with the filibuster with respect to Supreme Court nominees. So there is a little bit of precedence for doing away with the filibuster in a narrow instance, for example, certain types of legislation or Supreme Court nominees. That has not appeared to be the direction that Senator Schumer has chosen to go in. So I'm going to take out my crystal ball and say H.R. 1 is dead. And Senate Bill 1, which is its Senate counterpart, is also dead. So that leaves us with H.R. 4, which is the John Lewis Voting Rights Advancement Act of 2021. And this bill is a more narrowly focused bill. It seeks to undo the Supreme Court's ruling in the Shelby County case in 2013, which eliminated Section 4 preclearance in the Voting Rights Act. And it has also passed in the House, and it is lying in wait in the Senate. There's been a lot of negotiations, particularly over the August recess in the Senate, as to what to do about this piece of legislation. And there seems to be more support for this bill than there certainly was for HR 1 or Senate Bill 1. The bill would actually create a new coverage formula that would determine which states and local governments are subject to a new preclearance or Department of Justice approval for changes to their voting rights laws under the Voting Rights Act. And the federal approval would be required, as we've seen in the past, before changes to voting practices could be implemented in the states and localities. And those states and localities would have to have been shown to have a history of voter discrimination, or if the changes would fall into several categories that would be presumed to be discriminatory. Now, the thing to note about this particular bill is that it is a rolling coverage formula. It is a rolling 25-year window. So you could have an instance of discrimination in year 4, rectify it, have another instance of discrimination in a future year, and it would again start the 25-year rolling process. So that's the biggest thing to note about this particular piece of legislation. And the other thing that I've seen said about this bill, if it does pass both houses of Congress, it would impact the Brnovich decision, because Arizona's electoral practices would fall within the scope of these new preclearance requirements. So when would a state be covered under this new formula? So breaking it down, 15 or more voting rights violations in the state during the previous 25 years would trigger this new formula. 10 or more voting rights violations during that period, if the state government was responsible for any of those voting rights violations. 3 or more voting rights violations during the previous 25 years, if the state itself administers elections in jurisdictions where the violations occurred, and a county or other political subdivision of a state would be covered if it had 3 or more voting rights violations during the previous 25 years. So it is a new formula. There seems to be some movement on this that for the moment, we're in a hiatus period. I think some finer points are being negotiated out. Unclear when I pull out my crystal ball as to whether this bill will see the light of day in the Senate either. But I do think there is some movement toward, getting something in this area of preclearance done, perhaps before the end of the year, although that may be a little optimistic given that infrastructure seems to be taking over most of the bandwidth. And we are entering into appropriation season in Congress. So happy to answer any questions about those two pieces of legislation, but I do want to leave some time for you all in our audience to ask our esteemed panelists questions about these Supreme Court cases.
Thanks, Susan. I too have a crystal ball. It's often broken, but unfortunately, I don't realize it's broken when I read the predictions from it. So we'll see what happens. So we don't have any questions from the audience just yet, but if you have a question, you can ask it in the Q&A box or in the chat box, and I'm happy to ask it. I do, though, have a question for the panelists. Speaking of crystal balls, as we all know, it's redistricting season, which I guess is not, I guess it's all kind of in the election space, but we don't currently have an elections case at the Supreme Court that's been accepted. Anything of interest in the pipeline, Jessica or Aaron, that either of you are watching that you think might make it there, or some state that's destined for a redistricting case before the Supreme Court, as many of them seem to be? I won't mention North Carolina, it just seems to come up a lot. So ladies, any ideas?
Well, Lisa, as you said, it is redistricting season. And so I sort of have no doubt that that again will open kind of the floodgates of a pipeline of cases to the Supreme Court, especially given, of course, that most of these cases arise such that they come up on direct appeal from 3-judge panels. So, a much quicker path than, for example, the Brnovich case, which was initially brought in 2016 and kind of wound its way through the district court and circuit courts before getting to the Supreme Court. So I feel pretty confident that we will see some redistricting litigation hit the court, and then, if this federal legislation passes, I would not be surprised to see challenges to the federal legislation likewise end up at the court.
So speaking of controversy, someone asks about the newly enacted Texas voting bill, and what your thoughts are on how that might fare in a court challenge.
I'm among a group of counsel who has filed a complaint against the new Texas voting bill. We represent voters with limited English proficiency and voters with disabilities who are particularly impacted by the bill. Our claims that we brought are under the Constitution and the Voting Rights Act, but not Section 2 of the Voting Rights Act. So, that, as well as under the Americans with Disabilities Act. So I think people are certainly thinking about the impact of Brnovich on Section 2 claims as they challenge things like this new Texas bill. Certainly with respect to things like cutbacks on early voting and absentee voting and innovations that are sort of beyond what was available in 1982.
So,
Yeah, I won't.
Oh, go ahead, Erin.
I was just going to say, I won't kind of profess to know all the ins and outs of the law at this point, but I mean, I guess, my general sense, I think the reluctance on Section 2 makes some sense, but I think that obviously it takes cases a long time to get to the Supreme Court, but it sure seems like the mood music from the Supreme Court here is, I think to Jesse's earlier point, I think the Supreme Court takes kind of seriously the idea that the Constitution actually, whereas it says you're not supposed to restrict First Amendment rights, it actually affirmatively gives states the power to regulate the time, place, and manner of elections. And I think the court is going to be a little bit skeptical of claims that anytime you walk back anything once it's given, that's a constitutional violation.
So I don't see any other questions, and we are at 3:01. So I'm going to thank Jessica, Erin, and Susan for their time and information. I also want to invite the audience to attend the SLLC Supreme Court Preview webinar on September 15th. This event is free, and you can sign up for it on the state and local legal center's website. So thank you to everyone for attending, and have a safe, healthy, and wonderful day.